Act Section 2A MD2B of the Constitution, 25th Amendment Act and the Constitution, 29th Amendment Act are valid by majority. Per Hegde C. Ray, Jagan Mohan Reddy, Palkar, Khanna, Matthew Beg, Dwivedi, Mukherjee, and Chandrachud, J.I. The decision of the majority in Goloknath that the word law in Article 13.2 included amendments to Tal Constitution, and the article operated as a limitation upon the power to amend the Constitution in Article 368 is erroneous and is overruled by majority. Per Ray, Palkar, Khanna, Matthew, Beg, Dwivedi, and Chandrachud, J.J. The power of amendment is plenary. It includes within itself the power to add, alter, or repeal the various articles of the Constitution, including those relating to fundamental rights, by majority. Per Sikri, C.J., and Shalat, Hegde, Grover, Khanna, Jagan Mohan Reddy, and Mukherjee, J.J., Ray, Palkar, Matthew Beg, Dwivedi, and Chandrachud, J.J. Dissenting. The power to amend does not include the power to alter the basic structure or framework of the Constitution so as to change its identity. By majority, per Ray, Palkar, Khanna, Matthew Beg, Dwivedi, and Chandrachud, J.J., Sikri, C.J., and Shalat, HCGDC, Grover, Mukherjee, J.J., holding contra and Jagan Mohan Reddy, leaving the question open. The judicial arc no inherent or implied limitations on the power of amendment under Article 368 by majority. The first PEO Article 31C is valid for second part of the article, viz. When no law conta 1mg a declaration that TDTS for giving ecto such policy, canal 11 be called, cushion, in any court on the ground that it docs not give effect to such policy, one's invalid Sikri, Sijan Shalat, Hegde, Grover, and Mukherjee, J.J., held for both the parts of Article 31C invalid Ray, Palkar, Ma, Hugh, Beg, Dwivedi, and Chandrachud, J.J. held both the ports of the article validity, K. Kesavananda Bharati, Sikhan, C.J., as Jagan Mohan Reddy, J., held the second part of the article invalid and the first part of the article valid subject to the severance of the words inconsistent with or takes away, and the words Article 14 therein, Khanna, J., held the first part of the article valid and the second part invalid, per Sikri, C. the Constitution. 24th Amendment is valid, Section 2 of Constitution. 25th Amendment is valid, Section 3 of Constitution. 25th Amendment is void. The Constitution, 29th Amendment is ineffective to protect the impugned sections if they abrogate or take away fundamental rights. The Goloknath case, 1967 2 SCR prior 762 did not decide the ambit of Article 368 with respect to the powers of Parliament to amend Article 13-2 or to amend Article 368 itself, nor did it determine the exact meaning of the expression amendment of this Constitution. The leading majority did not express any opinion on the contention that in exercise of the power of amendment, Parliament cannot destroy the fundamental structure of the Constitution, but can zeromanly modify provisions thereof within the framework of the original instrument for its better effectuation. The conclude, Sion in Goloknath's case TL1 at the power of the Parliament to amend the Constitution is derived from Article 245, 246, and 248 of the Constitution, and not from Article 368 thereto, and that amendment is a legislative process, docs not survive for discussion any longer, because it was rightly admitted on behalf of the petitioners that the Constitution 24th Amendment Act, 1971, insofar as it trent, SFCRs the power to amend the Constitution from the residuary entry, Entry 97 List I, or Article 248 of the Constitution to Article 368, is valid. In other words, Article 368 of the Constitution, as now amended by the 24th Amendment, deals not only with the procedure for amendment, but also with the express powers of Parliament to amend the Constitution. It is not necessary to discuss the merits of the question whether amendment is law within the meanings of Article 13, as the same result follows in this case even if it be assumed in favor of the respondents that an amendment F the Constitution is not law within Art 13-2 of the Constitution P96. See Goloknath Var. State of Punjab, 1967, 2 SCR 672, Sri Sankari Prasad Singh Deo of Union of India and State of Buar, 1952, SCR 89, and Saiyan Singh v. State of Rajasthan 1965. 1 SCR 933 discussed Eke Gopan the State of Madras 1950. SCR 88 at 100 referred to the expression amendment of the Constitution does not enable Parliament to abrogate or take away fundamental rights or to completely change the fundamental features of the Constitution so as to destroy its identity. Within these limits, Parliament can amend every article, IID construing the expression 1 amendment of the Constitution, 1 MWT look at the whole scheme of the Constitution. It is not right to construe words in vacuum and then insert the meaning into article prior.